Happy New Year. This morning, I received an email regarding various new Georgia laws that took effect January 1, 2025. And one of those laws that was passed last year is one that affects Georgia's property tax appeal procedures. I had heard rumblings about upcoming changes last year, but I had my hands full dealing with 2024 tax appeal season and family issues to worry about it. I didn't want to think about the 2025 tax appeal season last year, but here I am the day after New Year's Day making a video on this because I think it's urgent that I do it now to get the word out. As I make this video, the 2024 tax appeal season is still not over for me. However, the new laws affecting Georgia's property tax appeal process took effect yesterday, January 1, 2025. So, I'm sucking it up the day after New Year's Day, downloading, reading, and digesting this new law in HB 581. I will have a link in the description area below if you want to download a copy of HB 581 and follow along. I'm going to give you my early impressions and interpretations of the updates and provisions described in HB 581. If you haven't already subscribed, I invite you to subscribe to my channel as the provisions of HB 581 gets rolled out in 2025. And if you have already subscribed, share this video with a friend that needs to know about the 2025 tax appeal updates. Before I dive in, let me make a quick disclaimer. I am not a lawmaker or a lawyer. I am not involved with Georgia politics in any way and have no connections to anyone. I have not yet conferred with any tax assessor's office to get clarification on the new provisions. But I have filed and been involved with over 250 tax appeals across 6 Georgia counties since the early 2010s. In the last 5 years, I've been educating property owners, landlords, and real estate professionals on the subject. I am like most of you. I am just finding out about this now and processing it in real time. The first update is in Section 1-3. Section 1-3 requires chief appraisers in every county to appraise every parcel at least once every 3 years. For many property owners, they are in for a big surprise. Property owners who have gotten away with not filing property tax appeals in years past may start feeling differently this year. So what I've done is I've printed out a copy of HB 581, and I'm going to focus only on the pages that are directly relevant to the property tax appeal process. On page 2, section 1-1, paragraph 3, as far as I know, this is not a change. However, it caught my eye because it is something that I'm going to want to discuss in a future video. And what it says is, fair market value of property means that the amount a knowledgeable buyer would pay for the property and a willing seller would accept for the property at an arm's length bona fide sale. And the only reason I'm touching on this is I'm getting reports from people that are saying that they're being pushed back on their tax appeals because they're not taking into account the condition of a property. And I would argue that any knowledgeable buyer would always look at the condition of the property. It is always a factor in any fair market value. But I don't want to harp on that for too long. I want to keep this video moving. On page 4, under section 1-5, there are a couple of small changes in wording. The small changes actually have a big impact to certain people. And let me go into it. It used to be that when you went through the BOE, and even if you didn't have a value change, you would still be able to get your 3-year tax freeze. However, in the new wording, unless you successfully argue for a value reduction, you will not get your 3-year tax freeze. In the old wording, it used to be that if you went through the tax appeal process in its entirety, regardless of whether or not the value was reduced or not, you would still get your 3-year property tax freeze. However, unless you get a value reduction, you will not get that 3-year property tax freeze. People who follow my channel and read my book are largely protected because I always tell people to present and argue for a value reduction. Essentially, what they're doing is preventing people from abusing the tax appeal process. In other words, you run through the tax appeal process and you don't submit any evidence, you just go through the motions and you get no reduction, but you still get your 3-year tax freeze. So they're putting a stop to that. Now, for your information, in my own appeals and the ones that I'm involved with, I always fight for the value reduction. But from what I've heard, there are other people who don't file appeals with the goal of value reduction. They simply are going through the process to get the 3-year tax freeze. Continuing on section 1-5, a lot of this text that I'm reading is the same as the existing text. Again, I've not done a side-by-side word comparison, but it looks pretty much to be the same text. Now, one of the things that doesn't get talked about is that you can, in fact, not go attend the BOE hearing as long as you provide written evidence in advance of the BOE hearing. Now, personally, what I generally tell people is you should attend the BOE hearing. This idea of submitting evidence but not having anyone attend on your behalf, to me, is a bad idea. But reading this, it made me think about people who are out-of-state owners that may not be able to physically attend a BOE hearing. Those out-of-state owners will want to take advantage of this provision of sending in the evidence in advance of the BOE hearing. One of the things in rereading this is that if you get a tax freeze, you generally don't want to file another tax appeal within those 2 years, because there is a danger that you will not only lose the tax freeze, you may in fact have your property valuation be increased. So reading this here in HB 581, I wanted to point that out to you. And finally, and this existed previously, the tax assessor's office always has the right to reassess a property with or without the tax freeze if there are substantial changes to the property. The way it's defined here is the Board of Tax Assessors may increase or decrease the value of the real property if after a visual on-site inspection of the property, it is found that there have been substantial additions, deletions, or improvements to such property, or that there are errors in the Board of Tax Assessors records as to the description or characterization of the property, or the Board of Tax Assessors finds an occurrence of other material factors that substantially affect the current fair market value of such property. Again, that existed before, but reading this in HB 581, I wanted to bring that up. In section 1-7, it appears that there is a provision to allow the tax assessor's office to conduct email communications with you versus doing everything by snail mail or certified mail or priority mail. And I really don't have a problem with that. It's sometimes such a slog to pick up the mail or look for the mail because you never know when a piece of mail may get lost on you. So generally speaking, I am generally in support of using email and modern technology to interact with the tax assessor's office. Now on page 8 of HB 581, a lot of the text appears to be the same. However, because it is in HB 581, it brings attention to the whole settlement conference process. Now, the majority of people don't ever go through a settlement conference because most people don't even know about it. The tax assessor's office and the folks at the BOE office do a minimal job in informing citizens about the settlement conference process. The settlement conference process is embedded as part of the appeal to Superior Court process. That's why it gets lost and most people never know about it. However, there is a lot of detail of how it's supposed to be done and how it needs to be conducted by both the tax assessor's office and the property owner. In general, let me make it easy. It's all about good faith. At this early stage, it's hard to tell if this verbiage will be problematic because in my reading, there's a lot of wiggle room in certain areas. But again, this is just my early impression, and I don't want to do a deep dive on the settlement conference and the appeal to Superior Court. But I do want to make you aware of it because it is very much spelled out in HB 581. Although this will probably not impact most of you, you should know that there's verbiage that informs property owners that they should engage in good faith and that they will not be able to get certain benefits from the tax appeal process if they don't engage in good faith. More specifically, whether or not property owners will get their attorney's fees back by going through the appeal to Superior Court process, or whether they have to pay in the property taxes provisionally due. Now, there's other helpful information regarding the steps that the tax assessor has to go through. If at the conclusion of a settlement conference the parties cannot reach an agreement, then written notice shall be provided to the taxpayer that the filing fees for the Superior Court must be paid by the taxpayer by submitting to the County Board of Tax Assessors a check, money order, or any other instrument payable to the Clerk of Superior Court within 20 days of the date of the conference. And the good news is that fee isn't that big a deal. It's $25. And if I had to pay $25 to continue an appeal that I was unhappy with and couldn't resolve with a settlement conference, I would do it. But again, that's a whole different topic of conversation that I'll do another time. As some of you know, I've published a book called Tax Freeze, which describes the Georgia tax appeal process. I've been careful to make the book applicable to all 159 Georgia counties because I know from personal experience, having dealt with 6 different counties, they all do things differently. Most counties do their own thing and follow their interpretation of Georgia law. Because I'm both a property owner and tax appeal practitioner, I'm constantly learning and adapting to changes. My Kindle customers will automatically get the 2025 updates, which I hope to get done by March. I will be taking the print book offline temporarily to prevent people from buying my book until I can make the 2025 update. Again, I hope to do this by March.